Cummins, you are up.
Morning, everyone. Thank you for entertaining oral argument on my case. I filed a petition for writ of certiorari to review denial of a motion to amend the complaint to add indispensable parties and to conform to the evidence, which showed that there were.
Cummins, can I ask you, isn't that the kind of order that is reviewable on appeal from a final judgment?
In this case, no, but normally, yes.
Why not? Why wouldn't it be reviewable on appeal from a final judgment in this case?
Because summary judgment has been entered, cutting off my ability to continue discovery, and that some of the facts that were found are adverse to my motion to amend. Additionally, the indispensable parties, the reason it's a miscarriage, I want to get my thoughts together. It's a miscarriage of justice in this case because the wrong standard was used to determine prejudice. Prejudice is notice, and these defendants had noticed the entire case that other people were driving this truck and that the person sitting in jail is cognitively impaired, that he had a 7th grade education, that he's physically impaired to prevent him from even being able to drive, let alone ride a bike. He cannot ride a bike. So because of the miscarriage of justice, the wrong definition of prejudice and the evidence in the case, which is being ignored, it deprives my clients of due process and access to courts. Additionally, the rule of procedure is to allow liberal amendment, and the policy of Florida is to allow trial on merits. If you don't allow me to amend the complaint now, and the judge has already indicated she's going to enter a final judgment, I'm not going to get a trial. My clients will not get a trial.
But then can you then not appeal that judgment, that final order, and raise this issue?
Well, I can try, but the problem is that the facts were not considered in the motion for summary judgment, and where the summary judgment was held over objection and over a motion for continuance. The prejudice to my clients in not permitting the amendment was several issues. One was the definition of prejudice, the irreparable harm is that these drivers are indispensable, and that the liability for the wrongful act by the person intoxicated is approximate cause of the injury of the dram shop case. Not allowing amendment doesn't go to the issues that are supposed to be heard on the merits by a jury. And we were told that we were going to trial, and we were told that we were going to get final judgment entered against us. So piecemeal litigation is what this court has previously said is not proper. And that's what I'm worried about. That's the irreparable harm to Ms. Egerton and the estate of Silloway. This is a 27-year-old young man who was killed by a drunk driver drinking at the bar. And
can I ask you a question? Shifting gears. Yeah, just shifting gears away a little bit as to whether or not this should have been an appeal or a cert. I want to focus on the relation back issue, because while we all understand that an amended complaint that raises matters that arise out of the same transaction or occurrence relates back to the original complaint as a general principle. My concern is when you're adding two parties after the statute of limitations have run, whether that relates back. And I have not really been able to find a single case that tells me that it does. Adding new parties is a different cause of action. And I read, through carefully looking at your cases, hoping to find a case that said exactly that if, adding a defendant after the statute of limitations relates back to this because of it arises out of the same transaction or occurrence. And I couldn't find one, and maybe I missed it. And that's what I'm asking you to do, is to help me identify that case that would tell me that.
Well, in this case, I can't answer your question on point exactly because this case is a derivative case. I'm not adding these two drivers as defendants. The derivative liability is to the bar. I don't have to have the driver on as a defendant. The action of serving someone who's habitually addicted to alcohol in looking at the circumstances of the case where the service occurred, we have facts that 3 men were drinking. They were drinking 2 rounds of 13 rounds of alcohol. We have video snippets of them sitting at the bar drinking. We have testimony of the bar owner saying any person who drank that much alcohol would be drunk. However, he also said in the video, in his deposition, that those people don't look drunk. But the liability goes to the bar, not to the 2 individuals. The tortfeasor is the driver, and the bar is liable for driver's actions because they serve the alcohol, overserve the alcohol. And this is not unlike vicarious liability claim or respondent superior claim, where
Right. So just to clarify, the initial complaint named at the time, supposed driver as a defendant, correct?
It did.
And then
that was my co-counsel, prior co-counsel.
And then dropped him as a defendant.
Yes.
And filed a request to amend. And the second amendment didn't name any new parties, but alleged that the driver was one of these 2 other fellows.
Yes. Yes, Your Honor. That's correct. And to try to answer your question, because I've done a lot of research on relation back, if the new defendant has some kind of relationship with the existing,
well, they have to have an identity of interest to get around. Generally, relation back doesn't apply to the addition of a new party unless the old and new parties have an identity of interest. And I don't
Correct.
see the identity of interest here is. But your point, I gather, is that you're not adding any new parties.
That's right.
You're changing not even the theory of liability legally, but the theory of liability factually.
Correct, Your Honor. Correct.
If I may, Ms. Commons, one of the things that I want you to address, could the court have come to the same conclusion of not allowing you to proceed, given the fact that time has passed? I mean, it appears that this incident took place in 2014. Can the court come to a conclusion, time has passed, now there's going to be issues with witnesses and discovery? Can't the court, within its discretion, come to the conclusion it will be futile because, again, time has passed? Can that be a basis?
I haven't found a case right on point to that. It does talk about that in the cases. However, in this case, we were allowed to amend the complaint in June of 2022. And in order to amend the complaint, we had to go through whether or not it was futile at that time. Now, COVID did put a couple years of delay in this case. And then after COVID, it was taking 6 months to get hearing time. So I don't think that my client should be prejudiced, because futile means that the claim is stale and the defendant didn't have notice of it. This client, these defendants have had notice the entire case. They have been at every single deposition. They heard the testimony of the person in jail that he was not the driver, and go talk to his family. So we took the depositions of his family, who I'm sure you've read their depositions. They testified very clearly and distinctly about his handicaps and his mental capacity, and the fact that he could not drive or ride a bike. He was being helped to be dressed. So defendants in this case have had notice. They chose not to take any depositions. So then they came in and argued, well, we're prejudiced because we didn't hear from this one or that one. But they chose not to take any of those depositions. And they have, I haven't even been able to finish the depositions of the employees. I was not given those for, months and months and years. This is their own making. Any delay in this case is their own making and their own choices. And they saw that he had, Mr. Rondulas, who's in jail, had been there one time, and they thought slam dunk, we're going to win. And we had the issue of the, video evidence being lost, and me asking for a Balsing instruction and a motion for rehearing on that issue. But they have known all along that this issue was noticed to them, and they chose not to do anything about it. I have been trying to take the depositions of the people that were involved, and we hadn't even finished one of the supervisors of the police that were investigating this accident. He drove off in the middle of the deposition, and I continued it and was not able to get him back yet at the time that this was pushed for summary judgment. And the other issue was that once the disqualified judge entered the order granting disqualification, I was supposed to have a rehearing on a motion to dismiss. Instead, I had to have a rehearing on a motion to amend the complaint again. But putting that aside, the policy of our state is to have trials on their merits. The rule is there to have trials on the merits, and the prejudice is defined as notice. In the Koppel case and in the Palm Beach case, they get very clear that you can have different facts, you can have different causes of action even, as long as it's from the same transaction, conduct, or occurrence. And Judge Nash even said that it was, and so did Judge Thomas. So I think it was just a misapplication of the word prejudice, which this court has previously defined in several cases. And then looking at our conforming to the evidence, my evidence on the depositions are unrefuted by the defense or respondent in this case. I have testimony that other people were driving, and one of the key witnesses is Mr. Lewis, who was an independent person, just stopped on the side of the road and helped. And he said, I cannot place Mr. Rondulas in the car. And he's the only one who didn't run away. We know somebody ran away. This is not, this is unfair prejudice to the petitioner, not the respondent. The respondent, the definition of prejudice in the case law on relation back is, did it come out of the same transaction occurrence or occurrence? And it has to only meet one of those three. And if it does, there's no prejudice automatically because of notice. It's a due process argument. Unfair prejudice is, for this respondent, is not there.
So can I ask you a question about jurisdiction in this case? This basically, you took an appeal from an order denying a motion for reconsider, or you took the petition for writ of cert from an order denying a motion for reconsideration. And that was 8 months after the trial court had originally entered an order granting the motion that you were seeking to have reconsidered. I don't think that the time to appeal is told during that period of time that you filed your motion for reconsideration. you want to address that issue?
Yes,
In other words, I think the appeal time had run long before you filed your motion for reconsideration, which is the order which you took the appeal from. Am I right about that?
No, sir. I filed the motion for reconsideration before the judge was disqualified, so it was within the 30 days of his decision where he changed his mind on allowing amendment of the complaint. At that hearing, I had no notice that he was going to change his mind. We were there for a notice motion to dismiss filed by the respondent. The judge had that hearing in September 6th, I believe, that year, and asked me to get the transcripts from the prior hearings in May and June, where I was telling the court that he had already heard the futility argument in order to allow me to amend the complaint in the first place. So post disqualification, I'm allowed under the rules to have the successor judge rehear the motion, and I filed that timely within 30 days. I was not able to get.
So technically, your petition is directed to the successor judge's order denying the motion to reconsider.
Correct. And that was on, we couldn't get a hearing until March
Right.
30th.
Okay.
And then she did not enter the order until July.
You didn't mention whether you wanted to reserve rebuttal time. You're 4 minutes left at this point.
Okay, I'll reserve. Thank you, Your Honor.
Okay, great. Mr. Metzger, you're up.
Yes, good morning. On behalf of the respondent, Joe Metzger. The petitioners have failed to establish that this court has jurisdiction to issue a writ of certiorari, and therefore this petition should be dismissed by this court. The trial court order that is the basis of petitioner's writ of certiorari is a non-final order. The trial court entered on July 20th, 2023 was an order denying petitioner's amended motion to amend the complaint following reconsideration of the motion. Since the order on which the petitioners are seeking relief is a non-final order, it is not a basis for a writ of certiorari.
Actually, Mr. Metzger, certiorari generally only applies to non-final orders. I think the question is whether there's an order granting a motion to dismiss with prejudice. That itself is not final, but the only thing that would remain to be done is the entry of an actual order of dismissal, correct?
That is correct, Your Honor. And under 9.130, you're right. Appeals to the District Court of Appeal of non-final orders are limited to those that, and then it recites,
Right.
a number of them. And this particular order for which the petitioner is seeking relief is none of those listed.
None of those. So in cert, you can only get cert if you don't have a remedy by appeal, and you always have a remedy by appeal from a final order. So cert almost always is from non-final orders, correct?
Very, very true, correct. And in this case, as the court inquired of Ms. Commons, this particular issue would be reviewable upon entry of final judgment. The trial court has not yet entered final judgment in this case. So that
What do you
time
think
period
will
has
let the
yet
judge
been
up?
fixed.
Why do you think the judge hasn't entered that order at this point?
The court had previously noted, well, a couple of things. I think in terms of the timeline, there was an overlap between the first trial court judge and the second trial court judge, and then there was the time period during which the hearing was pending. Ultimately, the court entered the order that is the subject of this petition on July 20th of 2023. The court had already had, and it was already scheduled before the court, a hearing on a motion for summary judgment. The court ultimately then heard that summary judgment, but then deferred, knowing that there was this pending petition, deferred on entry of final judgment, pending a determination by this court on this particular writ. So she deferred on that particular issue, but nonetheless, I anticipate that a final judgment would be forthcoming at some point upon reconsideration of the issue or further consideration of the issue by the trial court. In this particular case, the petitioner is arguing that there's prejudice and has argued that there's the concept of irreparable harm, among other things that demonstrates that there's no adequate remedy on post-judgment appeal. But in this case, given that there is that opportunity upon entry of final judgment, the petitioner has not demonstrated that there is a basis of irreparable harm in this particular case. In this matter, the petitioner has essentially prematurely filed this writ without a basis under 9.130, and whether that's 9.130 subsection 3 or 9.130 subsection 4, which pertains to orders disposing of motions for rehearing. And that's in essence what we are doing here. I know the court had inquired about the issue of the motion for leave and dealing with whether or not the relation back doctrine applied to this particular case. And as detailed in the briefs, and as detailed in the trial court order, both by the first trial court judge as well as the second trial court judge, this conduct did not arise from the same conduct, transaction, or occurrence. A couple of things. I know, Judge Kuzum, you had inquired of counsel about the delay. And that's one of the things that the trial court judge noted in her order dealing with the extensive delay. The incident at issue here was from August 10 of 2014. The motion for leave to amend with these new individuals dealing with the dram shop statute was in 2022. One of the cases that the petitioner cited, and it's buried within that case, but the Cinque, C-I-N-Q-U-E versus Ungaro case, it's at 622 Southern 2nd, 1051. It's a 1993 case from the 4th District. But in any event, in that case, the court noted, among other things, it said, we find neither undue delay by plaintiffs in undertaking discovery, which might be fatal to their position. And the case cited to Garrido, G-A-R-R-I-D-O versus Marcus at 358 Southern 2nd, 577, a 3rd DCA case from 1978. In this case, the timeline is particularly troubling. As noted in the petitioner's brief, the initial driver, Mr. Rondulis, was deposed back in 2018. It's the petitioner's position that thereafter, everyone was on notice that there may have been another driver. But the petitioner in this case waited 4 years after completing the deposition of Mr. Rondulis until 2022, and only after the petitioner had dismissed Mr. Rondulis as a party to the dram shop case did they then seek leave to amend, identifying 2 other individuals.
And your position and the lower court's position is in terms of your client's liability is that the serving of a habitual drunkard who then causes injury is not the same conduct, transaction, or occurrence as serving another habitual drunkard who causes injury, although the injury is caused in the same accident.
That is correct, Your Honor. If you look to the statutory language of Florida Statute 768.125, the dram shop provision, the language refers to as follows. It says it requires that a particular person who is furnished alcohol by the vendor or bar must be a person habitually addicted to alcohol. And furthermore, it must be proven that the bar or establishment knowingly served such person with knowledge that person was habitually addicted to alcohol and that the person who was driving was the one who caused the harm. So in this case, and as the trial court noted in its order, when you have a different person who is substituted in as the one for which the petitioner is seeking to impose derivative liability, whether it be Mr. Rondulis or one of the 2 others, Mr. Connell or Mr. Meredith, the factual background, the factual inquiry is separate and distinct. Whether or not Mr. Rondulis was a habitual drunkard is a separate question and separate discovery than whether Mr. Connell was a habitual drunkard, whether Mr. Meredith was a habitual drunkard. And then you impose on that the other statutory language dealing with, and the next step is whether or not the bar, the vendor, knowingly served such person. So knowingly served distinctly either Mr. Connell, Mr. Meredith, or Mr. Rondulis. And then beyond that, that the alcohol was such that the person became intoxicated, and then that person was the driver. All of those are separate and distinct factual questions that are, because they're different individuals. And the trial court in the July 20th, 2023.
Well, you know, and when you say separate and distinct factual questions, I mean, I would propose that saying whether these are factual questions might go to some prejudice issue, but in terms of whether it's the same conduct, transaction, or occurrence, those perhaps your side would say those are elements of a cause of action that are different than, you know, if you serve John versus Jim and John or Jim caused the accident, those are separate transactions.
Those are most definitely separate transactions. It's separate conduct and it's a separate occurrence. And the trial court noted that in its finding, and it stated in paragraph 1B of the order that the evidence of proof would be required between different individuals is substantial and does not relate back to the previous discovery that would be necessary to constitute support or finding for the entry of a jury verdict. So
Well,
yeah,
and
they
you know,
are.
at that point, when you're saying it's not the same conduct, transaction, or occurrence, then you get outside the rule of civil procedure, and now you're just strictly dealing with the discretion of the court, correct? I mean,
Well,
the
I
court
think-
could permit the amendment. The court could permit an amendment, even if it's not the same conduct, but it wouldn't necessarily relate back in time for purposes of the statute of limitations.
Correct. Yes, you need to apply the rule of civil procedure on that, and then there needs to be a determination or finding that in fact it would be sufficient to relate back. And the Florida Supreme Court, in addressing that issue in the Palm Beach County versus Doe case, noted among other things that amendments asserting new or different claims can relate back as long as they arise out of the same conduct, transaction, or occurrence as in the original. But when you have a different
And if I may,
person,
Mr.
it becomes.
If I may, Mr. Metzger,
Yes,
the fact that this is a derivative claim, does that render your argument a little bit different? Because it's like a relation back, it's a derivative claim. Who is really, you're dealing with the same, when I say same cause of action, that here's a bar that was providing alcohol to somebody who's known to be, you know, a drunkard. The fact that it's derivative, does that change the equation here?
the fact that it's derivative requires that, and you look in the statutory language of 768.125, it requires that it be that individual. So it needs to pertain to the individual, not a group, not to some friends, not to others who accompanied the driver, but it must pertain, and the order of proof is set forth in 768.125. So the derivative of liability arises from the conduct of the tortfeasor. Who is a tortfeasor becomes important in terms of what occurred, who was served, and then you follow the statutory language of 768.125 if that person was a known person who was habitually addicted to alcohol and that person was driving, etc. So
Well, you know, I will say though, you know, when you're relating, you know, it's derivative is a liability that derives from injury caused by the person who drank and drove. I mean, that doesn't necessarily mean they're a tortfeasor. I mean, the use of the word tortfeasor is problematic for me. I had a case many years ago when I practiced law, many years ago. And it involved this liability under this statute for a single car accident. And the driver of the car basically made himself, you know, messed him up for the rest of his life. But he was the drinker and he was the driver. You wouldn't call him a tortfeasor. He didn't commit tort against himself. So the statute says, you know, the liquor vendor is liable for injuries caused by. Doesn't mean by negligence or cost to someone else, correct?
Yeah, that's a fair assessment, Your Honor. And it's by the conduct of the person who was served the alcohol, provided that that person was one who was habitually addicted and that the vendor
Right.
knew that person was habitually addicted. Yes, I agree. That person does not become a FOBRE defendant, for instance, or someone put on the verdict form. But nonetheless,
Well,
the liability
so
is
let me come back though. And I mean, you know, and again, the question of conduct, transaction, or occurrence, right? And the law doesn't say same cause of action, correct? It
it
says
does not.
conduct, transaction, or occurrence.
Correct. That's the express language.
So, because one could argue, for instance, that to say, one could argue if you're talking about causes of action, it's a separate cause of action each time you serve, you know, serve drinker A versus serve drinker B versus serve drinker C. And, you know, one of them, you know, is a habitual drunkard and you knew it and blah, 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 and they have an accident. That you could argue that's a separate cause of action, but you could still have a new cause of action if it arose from the same conduct, transaction, or occurrence, correct?
That would be fair. Yes, I would agree with that. But here, what we're dealing with, we're talking, you know, the petitioner is attempting to insert individuals who were never previously referenced, not included in any of the prior allegations. There's no identity of interest between these individuals. They're, you know, they stand on their own. So whether or not the person who is driving imposes or can be subject to creating derivative liability becomes an inquiry as to whether or not the statutory factors of 768.125 can be established and proven. In conclusion, the petitioners have failed to establish first and foremost that this court has jurisdiction to issue a writ of certiorari, and therefore this petition should be denied. Furthermore, beyond the jurisdictional issue, the trial court properly denied petitioner's amended motion to amend the complaint following consideration of the motion as set forth in its order dated July 20th of 2023, and as a further grounds for denial of this petition. If there are no further questions, I am concluded with my comments. Thank you.
Okay, just one other observation, Mr. Metzger. We conclude, if we conclude you're correct and this petition for writ of certiorari, we don't have the jurisdiction because there's still pending a potential dismissal with prejudice, which then would furnish the other side a right to appeal. You recognize that this is going to be a do-over, at least on this issue.
Potentially, Your Honor, I do, but we're dealing with the petition and the issues before this court at this juncture. So what may come down the road, you know, that could be correct, but I think in looking at the petition as it's framed today, our argument and position remains as I've outlined in detail.
Yeah. Thank you. Thank you very much. Okay, Ms. Commons, you have 4 minutes for rebuttal.
Thank you, Your Honor. The jurisdictional issue, you have jurisdiction because this is a material injury, material misapplication of the law. The same conduct, transaction, or occurrence rule and case law are very clear that it relates back. You have piecemeal litigation here based on what's occurred to date, and we are adding indispensable parties, which this court has held is a material injury that is irreparable harm that can't be remedied on appeal. And this is also akin to the vicarious claims that show that who is the driver is not as important as did the bar overserve the alcohol to one of these three guys who killed a young man with a for a Ford 250 truck that he had just gotten that week. And it's very clear that the driver is not the issue. The driver is the tort that committed the tort. That we have a tort, we have a death, we have a drinker who killed somebody. The liability goes on the bar. Approximate cause is the bar over serving him. We have video evidence that's unrebutted that these three individuals that are in the amended complaint and in the original complaint were sitting together at the bar. There's Mr. Cannell's testimony is undisputed. We have the same defendants. We have both Mr. Cannell and Mr. Rondulas testified that they're all alcoholics. They admit that they're alcoholics and they're habitual. And Mr. Cannell testified that he had been to that bar a number of times so that they knew him. We don't have any evidence that definitely rebuts that. We have some testimony from Ms. Griffiths who says she doesn't remember them. And we have the issue of her saying she was really on the bowling alley that night, not sitting at the bar serving them. And she's not on the video serving them. So, and each person that I deposed, I showed the video snippets to. So the irreparable harm is, as I said, the wrong standard of relation back and the wrong standard of prejudice, the piecemeal litigation, and the liberal violation of the liberal amendment rule 1.190 and the policy of Florida to try cases on this. If you don't have any further questions, I thank you for your time.
All right.
This
Thank you both very much.
I appreciate your hearing my